Hello viewers, I am Professor Sharanjeet, working at the Rajiv Gandhi National University of Law, Punjab. In today's lecture, we shall discuss Motor Accidents Claim Tribunal Adjudicatory Mechanism for Claims. With the rising population, urbanization and an increase in vehicular traffic, road accidents are unfortunately very common and rampant. As India is a welfare state, through a legal framework, efforts are made to give justice to the victims of road accidents and their family members. Just and fair compensation is cardinal in this regard. The Motor Vehicle Act 1988 deals with various aspects governing the grant of compensation by the Motor Accidents Claim Tribunal. Furthermore, the different courts across the country have also given purposeful interpretation to the motor accident claim related provisions to ensure that social justice is actually done to the victims and their dependents. Dear listeners, sections 165 to 176, chapter 12 deals with accident claims tribunals under the Motor Vehicle Act of 1988. Section 165 empowers the state government, which may by notification in the official gazette constitute one or more motor accident claim tribunals for such area as may be specified in the notification for the purpose of adjudicating upon claims for compensation in respect of accidents involving the death of or bodily injury to persons arising out of the use of motor vehicles or damages to any property of a third party so arising or both. It is further provided that the claims tribunal shall consist of such number of members as the state government may think fit to appoint, and where it consists of two or more members, one of them shall be appointed as the chairman thereof. The Act further states that a person shall not be qualified for appointment as a member of a claims tribunal unless he is or has been a judge of a high court, is or has been a district judge, or is qualified for appointment as a high court judge. Where two or more claims tribunal are constituted for any area, the state government may, by general or special order, regulate the distribution of business among them. In the case of Orient Insurance Company Limited versus K.R. Shivaprakash, 1993, it was observed that the claims tribunal has all the powers of a civil court with the duty to safeguard the interests of the claimants. Similarly, in the case of Sarmanja Bai versus Madhya Pradesh Rajya Parivahan Nigam 1990, it was observed that the claims tribunal has the inherent jurisdiction to enforce its award in any area outside its territorial limits. The tribunal shall be within its power to follow the procedure applicable to civil courts in the absence of specific provisions under the Act. Application for compensation. Dear listeners, Section 166 provides that an application for compensation arising out of an accident of the nature specified in subsection 1 of Section 165 may be made by the person who has sustained the injury or by the owner of the property, or where death has resulted from the accident by all or any of the legal representatives of the deceased, or by any agent usually authorized by the person injured, or all or any of the legal representatives of the deceased, as the case may be. Every application under this provision shall be made at the option of the claimant, either to the claims tribunal having jurisdiction over the area in which the accident occurred, or to the claims tribunal within the local limits of whose jurisdiction the claimant resides or carries on business, or within the local limits of whose jurisdiction the defendant resides. The application shall be in such form and contain such particulars as may be prescribed. No application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. Option regarding claim for compensation in certain cases. Section 167 provides that notwithstanding anything contained in the Workmen Compensation Act 1923, where the death of or bodily injury to any person gives rise to a claim for compensation under this Act and also under the Workmen Compensation Act 1923, the person entitled to compensation may, without prejudice to the provisions of Chapter 10, claim such compensation either of those acts but not under both. Award of the Claims Tribunal. On receipt of an application for compensation made under Section 166, the Claims Tribunal shall, after giving notice of the application to the insurer and after giving the parties including the insurer an opportunity of being heard, hold an inquiry into the claim or, as the case may be, each of the claims, and, subject to the provisions of Section 163, may make an award determining the amount of compensation which appears to be just and specifying the person or persons to whom compensation shall be paid, and in making the award the Claims Tribunal shall specify the amount which shall be paid by the insurer or owner or driver of the vehicle involved in the accident, or by all or any one of them as the case may be. The Claims Tribunal shall arrange to deliver copies of the award to the parties concerned expeditiously and in any case within a period of 15 days from the date of the award. When an award is made under this section, the person who is required to pay any amount in terms of such an award shall, within 30 days of the date of the announcement of the award by the Claims Tribunal, deposit the entire amount awarded in such a manner as the Claims Tribunal may direct. In Nagima versus Jog Kurikose 1992, the court rightly observed that the main consideration for the Claims Tribunal under this provision is providing justice to the victim of the accident by way of compensation. No compensation that fails to balance loss and gain can be said to be just. The balancing of the loss of dependency against the gains by acceleration is an incomplete partial balancing of interest. A complete and just balance must take into account the loss of future savings and capital. This total balancing of loss and gain is the essence of just compensation. In Shanti Devi versus C.S. Chadha 1992, one of the most important factors that is taken into account for computing just compensation is the appropriate annual dependency of the dependents in terms of annual loss accruing to them due to an abrupt termination of a life. In the case of Chairman cum Managing Director BSRTC versus Manju B. Sinha 1992, the court observed that while determining the compensation, the Claims Tribunal must take into consideration not only the expectancy of life, but also the future prospects, chances of promotion and other relevant factors. Dear listeners, now we shall ponder upon procedure and powers of Claims Tribunal. In holding an inquiry under Section 168, the Claims Tribunal may, subject to any rules that may be made in this behalf, follow such a summary procedure as it thinks fit. The Claims Tribunal shall have all the powers of a civil court for the purpose of taking evidence on oath and of enforcing the attendance of witnesses and of compelling the discovery and production of documents and material objects and for such other purposes as may be prescribed, and the Claims Tribunal shall be deemed to be a civil court for all the purposes of Section 195. Subject to any rules that may be made in this behalf, the Claims Tribunal may, for the purposes of adjudicating upon any claim for compensation, choose one or more persons possessing special knowledge of any matter relevant to the inquiry to assist it in holding the inquiry. Furthermore, it is important to note that for the purposes of enforcement of its award, the Claims Tribunal shall also have all the powers of a civil court in execution of a decree under the Code of Civil Procedure 1908, as if the award were a decree for the payment of money passed by such a court in a civil suit. Impleading insurer in certain cases. Under Section 170 of the Motor Vehicle Act, where in the course of an inquiry, the Claims Tribunal is satisfied that there is a collusion between the person making the claim and the person against whom the claim is made, or the person against whom the claim is made has failed to contest it, it may, for reasons to be recorded in writing, direct that the insurer may be liable in respect of such claim, shall be impleaded as a party to the proceedings, and the insurer so impleaded shall thereupon have, without prejudice to the provisions contained in subsection 2 of Section 150, the right to contest the claim on all or any of the grounds that are available to the person against whom the claim has been made. Section 171 deals with the award of interest where any claim is allowed. Where any Claims Tribunal allows a claim for compensation made under this Act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date and not earlier than the date of making the claim as it may specify in this behalf. Award of compensatory costs in certain cases. As per Section 172, any Claims Tribunal adjudicating upon any claim for compensation under this Act may in any case where it is satisfied for reasons to be recorded by it in writing that the policy of insurance is void on the ground that it was obtained by representation of fact which was false in any material particular, or any party or insurer has put forward a false or vexatious claim or defense, such tribunal may make an order for the payment by the party who is guilty of misrepresentation or by whom such claim or defense has been put forward of special cost by way of compensation to the insurer, or as the case may be to the party against whom such claim or defense has been put forward. No Claims Tribunal shall pass an order for special costs under this provision for any amount exceeding Rs 1000. No person or insurer against whom an order has been made under this section shall, by reason thereof, be exempted from any criminal liability in respect of such misrepresentation, claim or defense as is referred to in this provision. Appeals. As per Section 173 of the Motor Vehicle Act 1988, any person aggrieved by an award of a Claims Tribunal may, within 90 days from the date of the award, prefer an appeal to the High Court, provided that no appeal by the person who is required to pay any amount in terms of such award shall be entertained by the High Court unless he has deposited with it rupees 25,000 or 50% of the amount so awarded, whichever is less, in the manner directed by the High Court. Provided further that the High Court may entertain the appeal after the expiry of the said period of 90 days if it is satisfied that the appellant was prevented by sufficient cause from preferring the appeal in time. No appeal shall lie against any award of a claims tribunal if the amount in dispute in the appeal is less than 1 lakh rupees. In the case of Matthew Alexander versus Bhaskaran Pillai, 1990, the court observed that upon the filing of an appeal to the High Court, the normal rules that have the application to the appeals before the High Court are applicable to such an appeal also. Recovery of money from the insurer as arrears of land revenue. Where any amount is due from any person under an award, the claims tribunal may, on an application made to it by the person entitled to the amount, issue a certificate for the amount to the collector, and the collector shall proceed to recover the same in the same manner as an arrear of land revenue. Dear listeners, now we shall discuss bar on jurisdiction of civil courts. Where any claims tribunal has been constituted for any area, no civil court shall have jurisdiction to entertain any question relating to any claim for compensation that may be adjudged by the claims tribunal for that area, and no injunction in respect of any action taken or to be taken by or before the claims tribunal in respect of the claim for compensation shall be granted by the civil court. Power of the state government to make rules. It is important to note that a state government may make rules for the purpose of carrying into effect the provisions relating to the working of the claims tribunal, and in particular such rules may provide for all or any of the following matters, namely, the form of application for claims for compensation and the particulars it may contain, and the fees, if any, to be paid in respect of such applications, the procedure to be followed by the claims tribunal in holding an inquiry, the powers vested in a civil court which may be exercised by a claims tribunal, the form and the manner in which the fees, if any, on payment of which an appeal may be preferred against an award of a claims tribunal, and any other matter which may be prescribed. Sarla Verma versus Delhi Transport Corporation is a landmark judgment in the matter of compensation for motor vehicle accident related claims in India. The court made a serious endeavour to simplify the determination of claims by specifying certain parameters. In this case, the court had endeavoured to simplify the otherwise complex exercise of assessment of loss of dependency and determination of compensation in a claim made under section 166. The claimants in the case of a death claim for the purposes of compensation must establish the age of the deceased, the income of the deceased, and the number of dependents. To arrive at the loss of dependency, the tribunal must consider additions, deductions to be made for arriving at the income, the reduction to be made towards the personal living expenses of the deceased, and the multiplier to be applied with reference to the age of the victim. The court determined and made a rule that 50% of actual salary could be added if the deceased had a permanent job and if the age of the deceased was between 40 and 50 years. No addition was to be made if the deceased was more than 50 years old. Further, the court ruled that where the deceased was self-employed or had a fixed salary, without provision for an annual increment, courts would take only the actual income at the time of the death. Another landmark case is National Insurance Company Limited versus Pranay Sethi, where a 5-bench judge of the Supreme Court has laid down guidelines on the fixation of future prospects in cases of motor accidents for victims who are permanently employed, received a fixed salary, or self-employed. The court in this regard observed that to have the perception that a self-employed person is likely to remain static and his income to remain stagnant is contrary to the fundamental concept of human attitude, which always intends to live it with dynamism and move and change with the time. The court considered various factors such as the passage of time, escalation of prices, human attitude to follow a particular pattern of life, and the change in price index, among others, and observed that the principle of standardization should be applied for a person with a fixed salary or a self-employed person. The court held that in case the deceased was self-employed or on a fixed salary and he was below the age of 40 years, an addition of 40% of the established income should be regarded as a necessary method of computation for future prospects. And there will be an addition of 25% where the deceased was between the ages of 40 and 50 years, and 10% where the deceased was between the ages of 50 and 60 years. Established income means the income minus the tax component. In case the deceased had a permanent job and was below the age of 40 years, in addition 50% of the actual salary should be added to the income of the deceased by determining the income towards future prospects. However, the addition should be 30% if the age of the deceased was between 40 and 50 years, and 15% in case the deceased was between the ages of 50 and 60 years. Actual salary should be read as actual salary less tax. Loss of consortium is one of the heads for determining the compensation. The right to consortium would include the company, care, health, comfort, guidance, solace, and affection of the deceased, which is a loss to his family. Parental consortium is granted to the child upon the premature death of a parent for loss of parental care, protection, affection, society, discipline, guidance and training. The Motor Vehicle Act is a beneficial legislation aiming at providing relief to the victims or their families in cases of genuine claims. In cases where a parent has lost their minor child or unmarried son or daughter, the parents are entitled to be compensated for loss of consortium under the head of filial consortium. The funeral expenses are also taken into account in determining compensation in case of the death of the victim in a road accident. In the end, I would like to say that money cannot substitute for a life lost, but an effort has to be made for the grant of just compensation having uniformity of approach. The Motor Vehicle Act 1988, as amended from time to time, is a beneficial and welfare legislation. The court is duty bound and entitled to provide just compensation irrespective of whether any plea in that regard is made by the claimant or not. With this, we come to the end of today's lecture. Thank you very much.